All right. Hello, inventors and entrepreneurs. My name is Andrew Krause. I'm one of the co-founders here at Inventor Groups of America. Type your name into the chat if you're new here. Say I'm new. Maybe type what state or country you're from. That would be great. Zoom kind of changed the interface. So if you don't see the chat button at the bottom, you might need to click on the three little dots and you can open up the chat. I highly recommend you do that. So we'd like to hear where you're from. IGA was founded by Stephen Key and myself. Stephen, raising your hand. So great. Don't you guys like my dollar store glasses? I lost all my glasses around the house. So these are literally from the dollar store. So I'm looking fashionable today. Anybody wants to compliment me my eyewear, I'd really appreciate that. So IGA was founded by Stephen Key and myself to teach individuals how to best commercialize their product ideas, as well as strengthen and support inventor groups throughout the nation. As many of you know, Stephen and myself also run a group called InventRight, where we coach inventors to license their products for royalties, which we've been doing for 25 years. At IGA, we have speakers on all sorts of topics that go beyond licensing. We're also very proud of the community we built here at IGA as well as at InventRight to help and educate inventors around the world. IGA also has a directory of local and regional inventor groups on our website. So if you're located near one, make sure to check that out. We encourage you to join your local inventors group. We're big advocates of inventor groups. They're kind of dying. There's not many of them, but if there is one near you, it's nice to hang out with some other inventors and realize, wow, there's a whole bunch of other people just like me. But these meetings are a great place to do that as well. Please do not disclose anything that is confidential and is not already publicly available. This meeting is going to be recorded and be harnessed on our website and our YouTube channel soon. If you have any questions for us, please type them into the chat as they come to you. We'll be doing some Q&A, maybe during and definitely at the end, okay? We have two speakers from the United States Patent Office, or otherwise known as USPTO. Both are currently patent examiners. You know the guys that approve your patents? So that's pretty cool, right? You're going to realize they're not somebody to be feared. They're really cool. Both of these speakers are amazing. But yes, they can accept your patent or not. I'm going to read off Wade and Miles's bios so you can see how super qualified they are to talk on the subject of today, which is provisional patent applications. Pretty cool that you can say patent pending for $60. Pretty amazing. So Wade is a primary patent examiner and assistant outreach coordinator for the Western Regional Office at the United States Patent Office. Wade has been an examiner in AU 3771. You got a lot of acronyms and stuff at the Patent Office since 2008 and a primary examiner since 2014. He examines a wide variety of medical devices for patentability, including stents, lancets, heart valves, and surgical robots. Pretty cool. Wade has also served as on numerous details within the USPTO. Sounds like he's in the military or something, including details with the Patent Trial and Appeals Board, Technical Quality Assurance Shop, and Patent Training Academy. That's pretty cool. Currently, he's on details serving as outreach specialist for the Western Regional Office, which is probably one of the reasons why he's one of our speakers today. Prior to joining the USPTO, he earned a JD from the University of Oregon and a bachelor's in biomedical engineering from Mississippi State University. I believe all patent examiners need some sort of technical background education. So you'll notice that of every patent examiner, I think, ever. They can correct me if I'm wrong there. Ali Sarouche is our other speaker, and he's a primary examiner and assistant outreach coordinator for the Western Regional Office as well at the United States and Patent and Trademark Office. Mr. Sarouche has served with the USPTO for over 17 years as a patent examiner in the biotechnology area, with special focus in pharmaceuticals, cosmetics, and herbicides. Interesting. Also, Mr. Sarouche contributed to several projects, including the development of a global dossier and the implementation of WIPO, that's the World Intellectual Property Association, I believe, standard ST26, a presentation on nucleotide and amino acid sequencing listing using XML. Okay. Yeah. Further, he was on detail with the Office of Solicitors and served as a trainer in the Patent Academy while at the USPTO. He received one distinct Department of Commerce Bronze Award. That's cool. He received a bachelor's degree in microbiology from the University of Maryland, College Park. and has a master's in science in biotechnology with a concentration in bioinformatics from Johns Hopkins and a JD from the University of Baltimore. So anyway, they're really, really qualified to talk on this subject. I mean, that's basically what it comes down to. Okay. All right. I'm not reading anything more. Wade and Ollie, do you want to raise your hand so everybody can? I mean, it's kind of obvious. You have the background. It says USPTO, but just in case. So welcome.
Thank you.
Stephen, before they start talking and exuding all their incredible, knowledge and all their extensive background at the patent office, is there anything you want to say about provisional patents to preface before we get started here?
Well, yes, I love provisional patent applications, and that's why I'm really excited about asking some questions that I don't really have the answers. I think I do, but I could be wrong. So I'm excited about this. Welcome, gentlemen. I think provisional patent applications gives us inventors a great start. It's an affordable start to start that process and determine if we should go forward and file a non-provisional patent application. So I think it's a wonderful tool. But that being said, I want to make sure we're doing it right. So welcome to IGA, and why don't we start the presentation?
Cool. Right. May I go ahead and share my screen if that's okay?
Yeah, you should be able to there.
Great. Thank you. And
welcome, everyone.
Thank you. And just let me know if you can see my screen now.
Yeah, we can.
Perfect. Great. So again, good afternoon, everybody. My name is Ali Sarouche, and I am a primary examiner at the United States Patent and Trademark Office. I'm currently working out of the San Jose regional office. So I'm cutting back a little bit on my examination time and focusing on outreach coordination. And so I'm just going to do this presentation, and then hopefully both Wade and I will be available for your questions. So it won't be too many slides. But first, quick disclaimer. The content presented today is for informational purposes and shouldn't be considered as legal advice. You should consult with the appropriate sources for legal authority and guidance on these matters. That being said, let's jump right in. So what exactly is a patent and what does it do for you? Well, a patent gives you the legal right to exclude others from making, using, selling, and importing your claimed invention. You have this right for a limited term, which I'll go over in a minute because it varies based on which type of patent you apply for. You should also keep in mind that a patent filed in a specific country provides protection that is respective to the country only. So there's no such thing as a worldwide patent, an international patent, meaning a patent that covers multiple jurisdictions. It is only in one jurisdiction. So US patents only protect you in the United States. And patents outside of the United States do not protect you in the United States. However, there is a specific treaty, the Patent Cooperation Treaty, or better known as the PCT, which allows applicants to simultaneously seek protection for an invention in 156 different countries. So again, it's not a patent protection in all those countries. It's just, I have an application, I can use this application and go to a variety of different countries. And use that as the application when I go to those countries, and then have to make some modifications because each country has their own laws and rules. So there are 3 different types of patents that you can apply for in the United States. The first, which I exclusively examine, are what's commonly known as utility patents. The other 2 include design patents and plant patents. For utility and plant patents, your term for protection will be 20 years after the filing date, and for a design patent, your term would be 15 years after the patent grant date. But generally, a utility patent is granted on processes, machines, articles of manufacture, or composition of matter. Again, remember, I primarily examine composition, so composition of matter is kind of like the area I work in. Now, for a design patent, it's more about the ornamental structure or shape of the device. It's actually kind of the reverse. Really, a design patent shouldn't be talking about its function, but what it looks like. So some examples of a design patent might be on jewelry or packaging, even computer icons such as emojis, the GUI, graphical user interface, things like that. So the third type of patent is a plant patent. These are really rare patents. Not a lot of people apply for them, but they include it is to a new variety of a plant that is asexually reproduced. So for example, the pink pearl apple was developed in 1944 by Albert Eder and granted plant patent 723, which was sold through California Nursery Company, originally based in San Jose. Again, today we're going to really focus on provisional applications, but this is kind of the path to a patent, right? So you're going to come up with an idea. And then in that second step, you're going to notice that there's two different applications, a provisional application and a non-provisional application. The provisional application is labeled optional because you don't have to file for a provisional application. And the non-provisional application is required if you want to get protection. That's where your protection for your invention comes in, is with that non-provisional application. It's the one that USPTO, myself and Wade are actually examining. So a little bit more about a provisional application is more relaxed requirements than a non-provisional application. And it's not reviewed for patentability. However, a provisional patent application can be filed to give an inventor a priority date at the date of the filing of the provisional application. So we're going to get into this a little bit more, but a lot of what the value in a provisional application is that it gives you an earlier date, gives you some time to kind of work through whether you want to file that non-provisional application. So the U.S. currently operates under a first-to-file system. So early filing is important, and the provisional application provides an easier and cheaper means of establishing an earlier filing date than a non-provisional patent application. And one major note here is the provisional application can only be used in utility and plant patent applications. They're not available for design patents. So as we go through this, again, keep in mind, we're really only talking about utility and plant applications. So this is kind of a graphic that illustrates that again. So there's a great use of filing your provisional application because it allows you to file without a formal patent claim. So you don't actually have to have a claim in a provisional application. That is a requirement for non-provisional applications. You don't need an oath or declaration. You don't need what's called an information disclosure statement. So you don't have to say, here's all the prior art, the references that are related to my application that I have found and I think are relevant to my area of invention and technology. So a lot less requirements. That's a big win if you're still trying to figure out, do I want to market this? Do I want to go forward with this? Am I going to spend all the money that it takes to file a non-provisional? So why is that priority date important? Well, currently the USPTO is acknowledging ownership in a first inventor to file system. And that's where the benefit of the provisional application comes in. You can establish an early filing date of your non-provisional application as the filing date of the provisional application. It's important to remember that a provisional application, I guess I'm kind of repeating myself, sorry, not available for design, but available for utility and design, utility and plant applications. And that's kind of like what the graphic is telling us there. So it's a cost-effective early filing date for your invention. Important things to note about a provisional application. It's not published, so it never becomes prior art in any way against you or anyone else. That's a big important thing to remember. And it's never examined. So you can file that provisional application. The examiner will never look at it, will never consider it until you file your non-provisional application. Then we start looking at it for support for what's in the non-provisional application and support for what's going to be claimed. And we're going to get into that a little bit more as we go through. So the provisional application will never result in a patent. Again, an important note. You will never get a patent just because you filed a provisional application. And they're only valid for 1 year. So you have 12 months to then file a non-provisional application. Otherwise, it automatically goes abandoned. Now, if, let's say that 12-month ends and you've, in the 2 months, like you're around 14 months and you realize, oh no, I forgot, I meant to. You can always file a petition and say, I made a mistake. I intended to file that non-provisional. I know I missed the date by a couple months. Can you please reconsider? And most of the time, yep, it'll be reconsidered and you'll get that provisional date still. Non-provisional, again, in contrast, non-provisional is what actually gets examined by us patent examiners, and that's what actually ends up resulting in your patent. So for you to get, and this is kind of where we're getting into that, what's that support? So for you to get, in order for you to, for your non-provisional to get the full benefit of your provisional application's filing date, the provisional must fully support whatever subject matter is claimed in the non-provisional application. So what does that kind of mean? It means that we're looking as examiners, when we're looking at the non-provisional aspect, we're looking at every element, every limitation that's in the claim and seeing, does the provisional describe that in some manner that one of ordinary skill would understand that you had possession of that limitation? And if they did, then you get that date of the provisional application, which is going to be your earlier date. If not, then you will get that date of the non-provisional date. So part of this is your claims potentially have a variety of different what's called priority dates. And those priority dates are important because that's how we determine what prior art or what references can be applied to reject your claims, or hopefully not reject them, but if they are rejected under some reference, that's the date we're going to look to see. So the patent term, however, is measured from the filing date of the non-provisional application. So if you file your provisional application, claim priority to that provisional application, that 1 year that you were trying to figure things out, you don't lose that 1 year. You still get your 20 years from the filing of the non-provisional application. There is one small caveat to that I should note. If you, and no one does this, so just be careful not to do this. If you claim priority to that provisional application, you don't lose your 1 year. If you convert your provisional application to a non-provisional, then you do lose that 1 year, because then your date goes back to the original filing of your provisional application. So it's a small caveat. I've never really seen it happen. Almost everyone understands that they're just going to claim priority and not convert. And Stephen,
could you explain that one more time again? Because I've never heard that before.
Yeah, so there's actually you can essentially, what you can do is when you filed your provisional and you're within that 12 months, you technically have two options when you're getting ready to go non-provisional. First option is, I have my provisional, I'm going to file a brand new non-provisional and claim priority to that provisional. And it's similar to, let's say you filed in a foreign country and you want to claim priority to that foreign, or let's say you have another application, you're claiming priority to that other non-provisional application. You're saying, I'm claiming priority to that. The other option is, I have this provisional, I'm not going to make any more changes. Let's say I have all my claims and everything is really ready to go. And I don't want to do any more work. I just file a petition saying, can you please make this now a non-provisional application? In that second instance, then the provisional date, the date you filed your provisional, will actually become your filing date. So in a way, you kind of lose that 1 year grace, that 1 year period that you would have gotten if you just claimed priority and filed a brand new non-provisional application. Like I said, I've never actually seen it done. I think because everyone understands that I don't want to lose that date. There's no real benefit in doing it that way.
Okay.
All right. So again, when you file your provisional application, you have 12 months from the date of the filing to submit your non-provisional. So that 12-month period may be useful for investigating market potential, obtaining counsel, or creating your business strategy. The other benefit of filing your provisional is that, let's say in the 12-month period, something happens, and for whatever reason, you decide that you don't want to file your non-provisional application. Well, the provisional application automatically gets abandoned 12 months. It's never examined. It's never made a public record. So your invention is, quote, safe from public record if you choose to let your provisional application go abandoned. So again, remember, it never gets published. It's never going to be prior art against you or anyone else. So there is that benefit if you decide, you know what, maybe my intellectual property strategy doesn't lie with a patent. It lies elsewhere. Or I just don't care if I have intellectual property. You don't give anything away. So what are some of the filing requirements for a provisional application? You'll need to include a detailed description of the invention as well as the appropriate filing fee. It's strongly encouraged to provide as complete of a description as possible in a provisional application. Again, because of that priority date. The more you provide, the more you can claim back to that date. But of course, again, this might be a fast way to get your filing date, so you might not have all of the details. Just that kind of have that the strategy that you're trying to figure out. So items that you want to include in your provisional application include a background, a summary, detailed drawings if that is something that's important to your invention. Some areas it's almost required. Other areas we rarely see those drawings because it's not going to really be useful or not necessary to explain your invention. My area, for example, compositions, right? So to describe a pharmaceutical composition with a variety of ingredients, not too much necessary to draw it out. You might include a drawing if you're talking about some of the properties of the composition in a variety of different way. Usually it's graphs and things like that, not so much a drawing of the actual product. Mechanical arts, for sure, you're probably going to want to include a drawing because you're going to refer back to that drawing to describe and explain. And all of these things that you're filing are going to be looked at for what we talked about, that support. Did you describe it enough in the provisional to give you that date in the non-provisional? For anything claimed in the non-provisional application that doesn't have support in the provisional, the effective filing date of the new subject would be the date of the filing of the non-provisional. So this is super important to know, and we can go back. So let's say that you have a chair, you describe the chair, the parts of the chair, but then you realize in your non-provisional there's this one other piece of the chair I want to include. Let's say caster wheels. Well, the caster wheels are not going to be given the priority date of the provisional, but of the date of the non-provisional. And so if there's prior art that comes in between those, it would apply for the wheels, but it wouldn't apply for the other elements. Okay, so again, filing requirements for a provisional application. You're going to see it, what you're going to want there. The title of your invention, the names of the inventors, residences, correspondence address, attorney information, and whether there is U.S. government interest. So, and then we provide a form. I don't think you have to use it. PTO SB 16, which would provide you the ability to just quickly, give us all of that information. So we did talk about that it's cheaper to file a provisional. So here's kind of like a, I believe it's the most current filing fees that you see. And here's a rundown of filing you can expect to incur when filing for a utility patent. Keep in mind that these are the minimum fees you'd incur, and you may have extra fees depending on the number of claims, late responses, non-electronic filing, and other case-specific surcharges. Also keep in mind that these are USPTO fees and not the attorney fees. So if you do get an attorney, they're going to have their own fees that can cost, not
Ali,
fees.
I like that
Yes.
$60 one in the upper right-hand corner. That's my favorite. That's
Yeah.
the one that most of our inventors use.
Right.
Can you talk a little bit about that?
Yeah, and I was about to get into that. So
Sure.
You're going to notice that what we call large entity on this table, it's actually not. That's not how we refer to it at the patent office. It's just so to distinguish between small entity and micro entity. It's the large entity is actually the regular fees. And then you have to qualify for small entity and micro entity. To qualify for small entity status, you have to, the inventors are either individuals, nonprofits, or small businesses, and small businesses are defined as 500 employees or less. So if you qualify in that manner, you are a small entity, you pay those small entity fees. However, if you want the micro entity status, you have to qualify for the small entity status and have no more than 4 previous applications, the income and an income of not greater than 3 times the median income. And I believe as of this year, it's around $212,000 a year. So that's and if you qualify for those 2 other things, then you are in the micro entity status, and you would qualify for that even lower level of that smaller fee. All right. Also, you can't have assigned your application, and this is for the micro entity status. You can't have assigned that application to an entity who's not a micro entity. So what does that mean? At least what that last part means is that you must not be under an obligation to sign, grant, or convey a license or other ownership to another entity that does not meet the micro entity income or number of patent application requirements. So what's the role of the examiner? Again, remember, we're in this case, we're talking now about the non-provisional, because an examiner will never review a provisional. So read and understand the application, search for prior art, make sure the specification and claims are up to code, and respond via office actions. And office actions are our correspondence with either the attorney or the applicant, which details the examiner's findings. So we can also hold what we call interviews at the applicant's request. These are usually an applicant will request to speak to us about. Usually it's after the first office action, or at least one office action, to talk about their application and what they think might be some of the differences. Usually they're about 30 to 45 minutes in length, and then we record the conversation as examiners and put that into the record. And I highly encourage including interviews in your patent process when you get to that stage, because there's usually, and I think there's some data to show across the patent office, a 10% increased likelihood of your application being allowed if you've had at least one interview.
Nice.
So here's our timeline, current timeline. The biggest chunk is waiting for that first office action. Right now, as of right now, we are working to reduce this backlog. Before you get your first interaction, that first office action from the examiner, we're approximately, and this is across all technology areas, it varies based on technology areas. Some are a little bit longer, some a little bit shorter, about 19.7 months right now. And then the rest of it is, will add up at each stage, right? And so you'll have kind of this round going around and trying to really clarify a lot of that language. And just keep in mind that once an office action is issued, you have, it usually says 3 months on there. They'll tell you, the examiner will say, you have 3 months to respond to this. You have 3 months, but you can always buy up to 3 more months to respond. After 6 months, that application will be considered abandoned if you don't respond. Now, I always say this, nothing in the patent office ever truly dies. You can always ask to revive if it does go abandoned, and almost always we will agree. You'll just have to pay a little bit more money, and that's kind of like one of the things that will get things back on track. All right, so I'm going to stop here, and we will, I guess Wade and I will try to take some questions, and then we'll give you some
So a
resources if we
final
have some time
notice
then.
is not really a final notice.
It's not. Yeah.
That's interesting.
Yeah.
If you want to come back, if you want to stop screen sharing, Ollie,
Yes.
that would be great.
Well,
Just looking for the button.
I have a few questions, of course, and then we'll go, and maybe Andrew can look through the chat and see if there's some other questions. Here's the big question. I filed that provisional patent application, and I'm trying to do my homework, but a year comes up pretty darn fast. And luckily, I haven't shown it to anybody. Can I refile it again and just lose that date, but have a new date?
As far as I know, yeah, I don't think there's any issue. Again, that provisional application is not prior art. It will never be published. So if you refile, you're going to lose your date. Yep, it's going to be the date of that provisional, and you can claim priority to that provisional that's not abandoned. Is the way we look at it. So as long as it's not abandoned, claim priority to that whatever provisional you have.
Let's say I did show it to a company to license it, not for sale, but to license it. And they did sign an NDA that said they wouldn't disclose it for 5 years. Can I still refile it?
Well, I believe it would be what was covered in that NDA, to be honest, and maybe also what are you disclosing when you talk to that company? If you're just merely showing a final product and you aren't showing like the details of how you're achieving whatever it is you're achieving, that's your novel breakthrough, you aren't really disclosing the novel features there. You're just kind of showing an end result or a final product. So you may, that it kind of comes down to what you are disclosing in those. I'm
disclosing my provisional patent application because they're under an NDA. That's not public disclosure, is it?
So here's my take on it. If you filed a provisional, again, I think I would say, and speak to an attorney before you disclose anything and how much you're going to disclose. The NDA, again, this is not the patent office wheelhouse where if someone breaks your NDA and goes ahead and, let's say, again, we're first to file. So let's say they come to you, you go to them and explain everything, and then they run to the patent office and file a non-provisional application before you get to it. You might have an NDA issue. That's not going to be our issue at the patent office. We're not gonna litigate that. We're not gonna worry about that.
Sure.
We're just gonna examine the application and worry about the dates. So I would say, just even in the case of an NDA, be very, very careful what you're disclosing and how much you're disclosing. Because then you have to litigate. Did they break my NDA? Did they break my NDA one day?
All right. So they could break it. There's a possibility they could break it.
Sure.
Okay, I got it. All right. The next question I have is, I file a provisional patent application, and people ask me all the time, am I protected in countries that respect PCT, that are in that 100 and some number? Am I protected in Europe or?
So you're not protected until you have a patent in each of those jurisdictions, right? So if you have a patent in the United States and let's say you even file a PCT, PCT is not protection. PCT is almost essentially an international provisional application. That one of the things to keep in mind about PCTs, by the way, is they do get published. So, they will eventually be published, the PCT. So it's out there. But they don't issue as patents, right?
I know that, but yes. I filed that provisional patent application in the United States, and I'm going to file in other countries, because I'm going to file before I file that non-provisional, or at the same time I'll file a PCT. So I still are going to have first priority date, correct? That's what I'm really looking for. Okay, in those other countries.
Right. Yes. So your priority date in the countries that have signed that treaty should transfer to those countries, right? And that you should have that date in place. So if you file your provisional and then you come in and file, let's say, like before in the time frame that you're allowed under the PCT, I think you have 12 months to then file the PCT, and then 18 months to go to each country.
Correct.
So you're like usually 30, I think it's 30 months. Certain countries will give you 31, some will give you 34. And as long as you meet those requirements, then you will have your priority date all the way back. Now, how those rules apply in each country, you have to look to those countries. In the United States, you will get, if you did a provisional, then file the PCT, and then file the non-provisional off that PCT in the US, you get your date all the way back to the
and for those of you who don't know what a PCT is, called a Patent Cooperation Treaty. I don't know the exact number, about 150 something countries, not companies. And so you could file a provisional, then you could go to the PCT, and then you could file in those PCT countries. It gives you a little bit more time to extend it to file in all those other countries. Doing that is incredibly expensive, so it's really great when you can assess, particularly when you're licensing a product, within the year of your provisional, if you can do something there, and because the PCT and filing internationally is very, very expensive. Stephen, we have you might have some more questions.
One more question, then we'll open it up. But this is a big one. I know everybody is going to love this question. I'm writing my provisional patent application, and I'm going to put a lot of details in here. I'm going to talk about workarounds, maybe some variations of how it could be made, maybe different materials. I'm going to talk, of course, the problem, solution, my invention, lots of drawings. I'm going to really be a lot of details. And the reason why I'm doing that is that when I file that non-provisional patent application, I'm going to get an office action. And I want to make sure that they can go back in case that non-provisional patent application is not that clear on a certain thing I talked about in the PPA. You can go back to the PPA and pull some information and make an argument to you why you could overcome maybe a prior art. Is that correct? Does everybody understand that?
So essentially what you're saying is if it's information that is in your provisional patent application,
Yes.
even if that information maybe isn't written exactly the same way into your non-provisional, can you still go back and pull some of that information to support your invention, correct?
Yes.
Yeah, that's information there that, it is in the priority chain.
Okay.
Sometimes what happens is, just in a matter of rewriting from a provisional to a non-provisional application, wording gets changed. It's not exactly clear, maybe what matches up. And so sometimes there is that lack of communication there, and it takes maybe a back and forth between the examiner and the attorney or agent to kind of say, hey, look, here's the support for this. Here is where we discuss this feature, and so that way, that link is being made.
The more
Right,
details actually is maybe a good thing for me.
Right. The more detail,
Yeah.
and I think it's something I mentioned in the presentation was, again, that support for what you're going to claim is probably the most important part, right? Because if you need to include more information into your claims or write your claims in a different way to overcome prior art, then the more you have in there, the easier it's going to be. Because if it's not there and you're like, no, but this was important, well, that's great, but you didn't have support for that, and you can't do that unless you file a brand new application. You're going to get a new date, and now we have the dates shifted again, right? And yeah, so I think that's an important aspect of it.
Thank you.
Okay.
I'm sorry, Andrew.
So yeah, we have a ton of questions. I just want to tell everybody definitively, we can only do PPA questions. I've got a bunch lined up. We can't do anything off PPA. The topic is PPA today. I know you got the patent office here and you want to ask them every patent question under the sun, but the focus today is PPA. So I'm sorry if we can't get to the non-PPAs, and PPA is just short for provisional patent application, of course, which you guys all know. But let's get in here. And guys, I don't think we have time for really in-depth answers. If you really feel like it's important to answer in depth, welcome to do that. But if you want to just knock them out, we can do that as well. So Jennifer, who's a past invent rights student, really sharp. She's really hitting it hard with Jennifer, with working on licensing your products. Said, how often, if ever, it's an interesting question. Never gotten this before, Stephen. How often, if ever, do PPA policies and requirements and standards change? Are they set in stone? And I just wrote, there are no formal requirements for provisional patent applications, but let's let the speakers answer that question. So question again is, how often do the PPA standards change? Can you guys comment on that?
I would say not very often. It would be a very lengthy process to really change those standards. And at least for the entire 15 years that I've been with the patent office, and even when I first became aware of provisional patent applications over 20 years ago, as far as I know, I don't know that those standards have changed in that time. Maybe a few small formality changes, but by and large, I work for my university's IP tech transfer office, and they were handling provisional patent applications when I was an undergrad the same way.
Yeah, that's as far as I know, and I can tack on a few more years to Wade's at the patent office, and yeah, no, I haven't seen anything that's any significant change. Again, maybe small formality things here and there, but nope, it's always been the same in the close to 20
And just
years
to
I've been in
confirm
office.
this, there are no formal requirements. There's good rules, but people can put whatever they want in there, and you guys will accept it. If you pay the fee and you put down your address, people that have this weird idea that you guys are approving it, or they have a patent, and sometimes people don't understand that it's not even reviewed. If you pay the fee, you put your address down, you're going to get it 100% of the time.
Right. And I think I had a slide where it showed like just the bare minimum. It's like a title, the description part, and an oath, and your name and address essentially is all like they're looking for it to be considered a valid provisional, and that's it. Because again, no one's going to look at it once you file it. Like there's a group that will look to meet to make sure that there's what's not called any missing parts, which is the parts I just mentioned, and that's it. And they're not even looking. Let's say, for example, the title is whatever you want to put there, and it's like, oh well, that doesn't really describe in detail what no one's looking to see if that's the case. And it's one of those cases where, and I think one of the uses of a provisional is you're getting ready to go to a trade show, and you have, let's say, you've written something up for the trade show, and you're not sure if going to that trade show is going to disclose your invention. You could almost take whatever you've written for that trade show and file it as a provisional, and make sure you get at least part of your date. You're like, I'm covered a little bit. Or if you're, let's say, you work in academic field and you're writing up your journal article for a scientific journal. Well, I've got everything there, but I don't have the time. Just, you can almost take that and drop it in.
Thank you.
Okay, great. Let's see. Next one was from Manny. What is the disadvantage of publishing? I think they mean publicly disclosing my idea and only filing a provisional patent application almost a year later. Wouldn't that buy time? So I think what they're saying is, like, maybe I publicly disclose it one way or another. I wait 11 months, then I file a provisional, then I get a year from that date for the provisional. And you're saying, is there any advantage or disadvantage there?
So there's a public disclosure, provisional, and then the filing of the non-provisional.
Correct.
So you have a 1-year grace period, and wait, I'll let you. So I apologize if I jumped in before you did. You have a 1-year grace period from your public disclosure to filing the non-provisional. Otherwise, even your own public disclosure becomes prior art.
So there's no grace period.
Yeah, there's no grace period.
I thought you could disclose it, then file the PPA, and then file the non-provisional, but you said that's not true.
You can file it so long as you are within that 1 year. Now, if you file the PPA after that 1 year, then that's where it becomes an issue.
Got it.
I think what you're really losing if you say publicly disclose your invention prior to filing the PPA is you start losing foreign international patent rights, because every country has different patent rights. And so in a lot of countries, the moment there's public disclosure, you have now lost those your patent rights. So while the US still allows you to have that 1 year grace period, internationally, you may run into trouble if you want to get into some of those international markets. I would say the other issue you run into is that, we are a first to file country now. And so if you publicly disclose that and then wait 11 months, somebody may file your invention before you file your own. And even though you publicly disclose that, that doesn't give you a priority date. That doesn't give your invention a priority date over your competitor.
So even though they can do it, it's just generally not a good common sense thing to do. It's too risky. I mean, yeah, and they're trying to buy more time, I think, is what they're trying to do. But
and a lot of times it's setting yourself up that even if you are in a legally defensible position, it's going to cost a lot of money to defend your position. So, you don't want to set yourself up where you are now having to go into court repeatedly in order to, protect your patent rights.
Right.
Yeah. Okay, great. Next one, Margie is a longtime member. She's fantastic. She said, I have a simple product that can easily be shown in a photo. Can I use the photo in the provisional patent application instead of drawings? Do they need to be black and white? Thank you. Good question.
So, yeah, you can include photos as drawings in your patent application. They do need to be black and white. If it's a situation where the only way you can it's essential for it to be in color, for example. Like there are some rare situations where there's no other way other than for it to be color. You would have to petition for it to be in color. Otherwise, it will be in black and white. And in most cases for our uses, black and white's good enough.
Okay, but it can be a photo. Just needs to be black and white. Got it. Okay.
Hey, let me ask this. There's a great question here. You file the PPA at the USPTO, a year's up. what do you guys do with it? Do you throw it away in the trash, or do you?
I mean,
Yeah,
it's a digital file. It's
Yeah.
it's not published publicly. As far as I know, maybe it's on a server somewhere that gets wiped at some point. But there's no public access to that unless there's like a critical hack issue with the USPTO that accesses our system.
All right.
They, even though it's not, most people are filing these digitally now, so there's not an actual paper copy that has to get shredded or anything. It's just a digital copy. It's in our system, and I unless we have the actual, unless the provisional application is listed in the priority of an application, or referenced otherwise in an application, we will never know what application it is to even look up. So like, we don't even know how to find it.
I'm glad you're
It's not
mentioning
included.
that.
Yeah, it's
because
not included in our search tool. So it's in our filing systems. It's there. Like, so you would need that number to look it up. So without that number, there's no way, even internally, we could find it.
I'm really glad you guys are talking about this, because I can't tell you how many inventors that talk to Stephen and myself, and they feel like when that year's up, they've lost all their rights. Because a patent attorney calls them and says, oh, if you don't file a non-provisional, you're going to lose your priority date. And they're not giving them all the information. They haven't even made any public disclosure anywhere, showed it to anybody. And the patent attorney is giving them this impression they're going to lose all their rights, and they're not. They're going to lose that date. But if they haven't made public disclosure, they're not going to lose their rights. And you guys confirming, look, that's never going to be published. Nobody's ever going to see it. You're not losing anything. You're going to lose the date. And it's as if, correct me if my wording's wrong, if it never happened. Correct?
Right.
Okay.
The main issue with losing that date would be, again, if a competitor in the interim has now filed their own patent application,
Sure.
you lose your date, and now they are the first to file.
So this one's from Caesar. Are there any specific rules for filing the manufacturing method in a PPA? So a method of manufacturing something, that's Stephen's area of expertise. And how extensive must the description and the drawings be to be considered useful to a prospective licensee? So they want to file a provisional patent, but it involves the method of manufacturing. Can you guys comment on that? Stephen might want to chime in after you guys do too.
Yeah. So whether it's the product, the method, composition matter, method of, and when I say method, it could be either the method of making, method of using. All of that is, you just need to describe it as in a way that one, again, and I'll say this for us as at the patent office, and I'll leave the licensing kind of to the side. For one of ordinary, for support, what one of ordinary skill in that technology area would need to be able to reproduce the invention, right? So
Okay.
it doesn't have to be every little, tiny detail. If one who understands how to make that thing, or has the technical expertise, if they were given some information to make it, then just that amount is what we're looking for.
If I live in South Africa, can I file a PPA and then file a non-provisional in the United States?
Yes.
Okay, thank
You
you.
guys don't discriminate against people from other countries? People are always happy to hear that.
Let's sort of say, you don't have to be a U.S. citizen or resident of the United States to file
Nice.
for a patent in the United States.
Nice. Yeah, I was sorry. I was stating that in a funny way, but you'd be surprised. I talked to a lot of people in other countries, and they feel like they're not going to have the same rights. Are they at any disadvantage? Do they have any less rights in any way? That's a big question, than an American citizen.
Nothing that I can think of in any way.
Pretty
no.
cool.
They would have, essentially it would be examined in the same manner. With a non-provisional, the provisional is exactly the same. Non-provisional will be examined in the exact same manner. Their protections would only extend to the United States. It wouldn't extend outside of the United States. So all of the same things.
People ask this all the time. At InventRight, we have a software called Smart IP, which was designed by Gene Quinn, and it is a nice format that's really easy to understand. Is there a format that you guys eventually would like? I know you work with the patent attorney when you filed the non-provisional. application, but eventually you might see that PPA and look at it. Is there something that tips you can give us? I know you told us to just give a lot of details, but is there something that you like to see that's easy to understand that makes it easier for you? Format, any format?
Yeah, I mean, I think so. Again, not required, not necessary. The closer it looks like a non-provisional patent application, the easier it is for me personally to read, because obviously I'm looking at non-provisional applications all the time, every day, and so to be able to like just it makes it easier. I know what sections to go to. I know where what to look at.
Okay.
But no, I mean, I think even if it's not in that format, it you know do the best you can. But like, yeah, though it's that might make it a little bit easier for me to look at if it's closer to what a non-provisional looks like.
Got it.
Stephen, there's a related question that Margie typed in. Does the patent office offer any help to independent inventors with writing their PPAs? And I'm just assuming you guys aren't allowed to give legal advice. Is there any training you guys offer? We at our company, InventRight, we have some software that helps people do it. But is there any training you guys like? Where does it kind of cut off? I think some people have this impression like if I go on and I apply for a patent, it's going to tell me what to write. People that are very new inventors, right? And it's like, and then they are in for a rude awakening. Oh, the patent office isn't going to tell you how to write it. They're going to tell you how to file it, but not how to write it. And is that accurate or am I off there?
Yeah, we can't get into like kind of when it comes to writing your application, that's getting very personal as to like your legal decisions on how you want to represent and protect your invention. So we at the USPTO, we can't be involved in that. That's not our role. We're here to we have we have a program series called Path to a Patent. It's an 8-part series that we run every quarter. It's free to the public. But for instance, I kind of describe that series as what it's doing is it's giving you the education and the background so that when you go talk to a patent attorney or a patent agent, you can have productive discussions with them about the patent process. And without spending, valuable time and money, having those like kind of that background information and just understanding what's going on, you aren't having to learn that from the attorney. We can kind of teach that to you so that I know a lot of people here are like, oh, PCT, what's that? PPA, what's that? All the acronyms. When you go in there and that attorney uses some of those acronyms, you'll be able to stick right there with them. That won't, that's time. Time is money, and everybody is concerned about attorney fees. So we're here to help save, kind of give you that background so that those meetings can be faster, they can be more efficient, they can be more productive. We do have some resources with like pro bono programs and the university law clinic programs that are through the USPTO, but that the inventors can reach out to and may be able to work with, that can provide some more of that hands-on, maybe more of that like how to write their application help that we can't provide as the office ourselves.
Also, we have the Inventor Assistance Center. So there's a number and an email you can contact if you're an inventor who's working through the process. They will help you again, as you said, Andrew. Everyone at the office will kind of start to, as it gets closer to, oh, we're providing legal advice or business strategy, we'll kind of start to, all right, that we might be going a little bit too far. You're going to want to hire someone for that. We also have the helpline. So we do have resources via, we have the trainings, which Wade had just mentioned, and then we have the resources that I think as you're doing it, if you're in the middle of like, hey, I'm writing this, I'd like some help. What do I need to file? How do I file this? That kind of thing. I would say one of the probably the best resources if you're confused what to include, especially in that description part, is look to patents that are in your technology area, right? So if you're like, hey, I'm making a new battery, look to applications that have published or patents that have issued that, are in the battery area, and just use that as your template. Sometimes you can even, there's no what is it, plagiarism in the patent world. So you can copy, if you wanted to copy some of that background information, so do it. That's fine. The claims are what's going to give you the protection, and that's
Andrew, we're running out of time. So I know they have a lot of resources at the USPTO. Maybe these gentlemen could explain all the different things they do and how we can
Yeah.
get more help, because there's so many questions. There's no way we can get to all of them.
Right, yeah. There's whenever the patent office shows up, they're like, people are like, I'm gonna just do all these, and we couldn't even get to all the PPA questions, let alone all the questions. So we'll have another session tomorrow, guys, that will run for 10 hours straight. And Wade and Ollie are coming back. No, just kidding, we're not. But
So what else does the USPTO do, you guys, for us?
Yeah. Here, I can provide some resources here real quickly. I'll share my screen for everyone to see. All right. Is that visible to everyone?
Yes.
Yeah.
So we have here, these are our regional offices. We have four regional offices right now. Our East Coast Regional Outreach Office is based out of headquarters. But coming up later this year, we'll be opening a Southeast Regional Office in Atlanta, Georgia. The regional offices, that's who Ali and I are working through, is the West Coast Regional Office. We're doing outreach events like this. Lots of others up and down the West Coast, Hawaii, Alaska. So we're all over. You can reach out to your regional outreach office and find out what they have going on in your region. They can help you, point you in the right directions. We also have a lot of free services. You can see here, if you just go to uspto.gov/free services, you can click on what you need. You can click on all resources, patents, trademarks. It'll kind of guide you towards the resources we have available depending on what you are looking for. Ali mentioned this. We have the Inventors Assistance Center. This is staffed by former supervisory patent examiners and primary patent examiners. What they can do is they can answer questions with examination policy and procedure. They can, a lot of the forms, like what forms need to be included, how do I fill out this form? These are people who can help you with that. Again, these are through the USPTO, so they can't really help you write your application, but they can answer all those questions as far as like what forms you need.
Let me interrupt for just a second, guys. I know the USPTO is a government agency, but they're completely funded with your patent dollars. And they're a lot more customer oriented than some people would believe other government agencies are. I tell people, please just call the number and ask for some help, and you'll be blown away with how helpful they are. And people come back and they're like, Andrew, that was surprising. They were really helpful. They're having a hard time filing their PPA, or they don't know how to fill out this part of the form or that part. They are very, very helpful. So don't think, oh, this is a government agency, I'm just going to be put in a voicemail hell for 2 hours and then they won't be helpful. That's not true. They're very, very helpful. I'm not just saying that because they're on here. I'm saying it because it's true. Okay.
Yeah. So in addition to the assistant center, we have I mentioned our patent pro bono program. It's a nationwide network. Assist under-resourced independent inventors and small businesses. So again, there's some usually with the pro bono programs, there are some income requirements similar to that of the micro entity status and small entity status. So if you think that's something you may qualify for, check out uspto.gov/pro bono patents. See what pro bono programs cover your area, and you can look a little bit more into those. You can see here we have a map of the country. There's a lot of different shades of colors, but you can see at the bottom, those correspond to different pro bono patent programs that are available to people in those regions.
Cool.
I also mentioned our law school clinics. Those are at I think over 50 law schools around the country. They're spread out pretty widespread, so you can look there at uspto.gov/law school clinic. and see if there is a participating law school in your area. Reach out to them, and you might be able to get help through their clinic to help write your application. These are some of the resources where, you know, like they can actually help you with the writing process itself, something we can't do with USPTO. This is our final big resource, the PTRC, or Patent and Trademark Resource Centers. It's a nationwide network of libraries. They're public libraries, state libraries, university and academic libraries. There's quite a bit of variety, but they are designated by the USPTO, and they have a librarian on staff who is trained by the USPTO. They can help you access resources. If you're looking to do a preliminary search just to find out what's out there as far as your technology, and whether someone has already patented your invention, they can help you start that process of searching. They can show you how to do that. So there's a lot of things they can offer. They also do public community outreach themselves, hosting their own events, so you can keep abreast of the local events being hosted by your PTRC in your area. Again, you can go to uspto.gov/PTRC, and you can see a list of all those PTRCs, and reach out to some of those in your area if you're looking for help with navigating the USPTO and the patent process. Finally, this is just our catch-all slide with our other resources. You see the helpline number there at the top. That's probably the big one you want to keep in mind. If you call that number and you have a question, whoever is on the other side should be able to point you in the right direction to find your answer. Also, we have micro entity information here. I know it was something we discussed earlier. That's down there at the bottom, so you can go to that link, uspto.gov/patent microentity, and find out all those requirements to meet microentity status. With that, that is the end of our resources and the end of our slides here for Ollie and myself.
Cool. Hey,
Oh,
Stephen, what I
very-
want to do is, for those of you don't leave yet, we're gonna do a group shot, but I'm gonna turn my camera off. I'm gonna stay on. If you guys have a sec, please write your thank you for Wade and Ali in the
Thank you.
chat. I'll turn my camera off, and then you guys have plenty of time to write your thank you. So don't just leave. Try to write them a thank you before you leave. Stephen, go ahead, and we got to do a group
I was
shot.
going to say the same thing, Andrew. You beat me to it. So,
Okay, great. All right, so we're gonna do a group shot. I don't know how many pages of people are on camera, but you're gonna like give a thumbs up or a wave or a smile or whatever. Don't do anything bad. But and we're gonna do that. So here we go, and I gotta do a couple pages here. So everybody wave, smile, and that's page 1. And I don't know how many pages, page 2, and page 3. And the other 3 pages, we don't have people on camera. So thank you guys, appreciate it. Stephen, was there anything you wanted to say in closing?
no, I just want to thank the USPTO for doing a really great job. Thank you very much. We do appreciate you coming on, sharing all that information. And we also really appreciate that there's so much information that you guys provide. You're right. Andrew said it. Your customer service is amazing. I don't know how you do it, but you do it. You do a great job. Thank you so much. But I also want to thank Courtney for making this happen, and Madeleine Key as well, for pointing us in the right direction to have the USPTO and joining us. So if you have more questions, make sure you reach out to the USPTO. They're there to help you protect those great ideas that you have. And thank you so much.
All right. So guys, we're gonna call it a night here. I'm gonna turn off my camera, but I'm gonna leave the whole meeting on for about 15 minutes. If you guys could type some detailed as possible thank yous to Ollie and Wade, that would be great. And then in about 15 minutes, I'm going to close it out. But we're done here. You can check the recording on our YouTube channel, on the Inventor Groups of America YouTube channel, as well as the website, and it's free. So if you joined and you missed part of it, or you want to rewatch it, you can check it out there. And Ollie, Wade, thank you so much, guys. I really appreciate you guys. Thank you.
Thank you.
All right.
Thank you for having
See you
us.
guys. Keep inventing, everybody. Bye.
Good night, everybody.